Hello, everyone. This is Matt Thompson, and I just wanted to come on live this morning and give everyone an update on what's going on with the Jeff Weinhaus case and what I know about it. I know a lot of people are concerned about Jeff and just wanting to know what's happening. So I wanted to just get on here and give an organized review because a lot has been happening in the last couple of weeks, and I wanted to give everyone an update. I won't wait for everyone to get on here. But you can play back from the start and get whatever you've missed. But just as a matter of review, I got involved with Jeff Weinhaus case a little over a year ago because I think it's a very important case for the foundation of our society. Because we have to be able to criticize our government for our system of government to work. And I think in Jeff's case, he annoyed government officials. He criticized them, and he published bulletins and criticizing them. And he suspected them of corruption, and he was running for coroner in order to, if he was elected, have the power to conduct an inquest into the activities of the local sheriff. And this is what started the whole thing. Jeff criticizing the government. And many of you know he was shot on September 11th, 2012. He was shot twice in the head, twice in the chest by Officer Henry Folsom, who was one of those that Jeff had been criticizing. Folsom was with the Missouri State Highway Patrol. And subsequently, Jeff was arrested and convicted and sentenced to 30 years for assaulting Folsom, which he didn't do. And I'll get into a little bit more of that later. But just wanted to give a quick review of what's happened in the last couple of weeks because there's been yet a lot happening. First of all, on August 13th, I think it was, they finally issued a ruling in Jeff's federal case for habeas corpus. Jeff's attorney, Warren Markowitz, had worked on this for a long time with Jeff. It's been in the process for, I think, 3 years now. Trying to get Jeff granted federal habeas corpus relief for wrongful incarceration, wrongful conviction. And the ruling was issued on August the 13th, and his petition for habeas corpus was denied. And I'm going to read a little bit of that stuff. I'm going to read from Jeff's response to it. He filed an application for rehearing, and I think in there we can hear the basics of the case are outlined in there. And the habeas corpus, the conviction was for assaulting the officer and armed criminal action. Jeff did have a gun when he was shot, but video evidence later proved that he never reached for his gun. There was eyewitness testimony that both his hands were in front of him. He never reached for his gun. So Petitioner Weinhaus was convicted of assaulting Officer Henry Folsom with a firearm by shooting him. However, Folsom was not physically assaulted with a firearm, and no weapon was fired at him by anyone on September the 11th, 2012. The alleged assault by shooting did not exist. It's argued that Weinhaus intended to assault Folsom, but was himself shot first. And then it goes over the requirements for conviction for assault. There is a reference to another habeas corpus case, which was decided in Missouri in 2006 for Weir versus Moore, was decided by Judge Limbaugh. And in that case, the facts of the case were that the petitioner for habeas corpus had grabbed a person by the throat, stuck a pistol in the alleged victim's side and cheek, and stated that he would blow his effing head off. Yet the petitioner was granted habeas corpus because he did not shoot the alleged victim, and it couldn't be shown that he really intended to assault the victim with his firearm. In the Weinhaus case, Jeff did not verbally threaten to shoot the officer. The officer perceived a threat from Jeff's exercising of his right under Article 1, Section 23 of the Missouri Constitution and Amendment 2 of the Constitution of the United States. The officer was not physically assaulted, and he suffered no injury other than a self-inflicted wound to the hand. The errors in law inherent in this ruling in the habeas case are strikingly apparent in a reading of the conclusion. And the conclusion states, this court concludes that there was ample evidence for a rational jury to find that by bringing loaded guns to a meeting with police officers, opening his holster, resting his hand on the gun, and telling officers that they were going to have to shoot him, petitioner took a substantial step towards assaulting Officer Folsom. The evidence further allowed the jury to conclude that petitioner was not issuing idle threats, but in fact intended to carry out an assault on the officer. Petitioner's statement, "He should have placed a bullet in Folsom's head," demonstrated an assaultive intent. A rational jury could find petitioner guilty of assault beyond a reasonable doubt, and the state court was reasonable in upholding the conviction. So that's why the federal court denied his habeas ruling. The first sentence, this is from Jeff's application for rehearing. The first sentence of the conclusion cites evidence that petitioner intended to commit an assault that did not physically occur. The first evidence cited is that petitioner brought a loaded gun to a meeting with police officers. This is an error in law. The exercise of a fundamental individual right that is clearly and unambiguously protected in the Second Amendment to the U.S. Constitution cannot and must not be considered evidence of intent to commit a crime. To consider it such would be to remove a right that all laws within the United States of America cannot violate. The conclusion then states evidence from the testimony of Sergeant Henry Folsom that petitioner opened his holster, rested his hand on his gun, etc. as fact, without mentioning the video evidence in the record that clearly shows that petitioner did not have his hand on his gun, nor did he open his holster, which required two hands to open. Neither did the magistrate consider the two FBI officer witnesses' testimony that petitioner did not have his hand on his gun, nor open his holster, which was in the court record and in the possession of the prosecution, but not shown the jury. A most egregious error in law comes when the ruling states petitioner's statement that he should have placed a bullet in Folsom's head. This statement was taken out of context from a video that was not shown the jury, in which petitioner said if he was 10 years younger, he would have placed a bullet, etc. Thus, the statement does not show intent, but rather the opposite. Magistrate has taken as fact a prosecutorial quote of a statement from a video that was not shown the jury, and he's taken it out of context. Finally, the magistrate did not consider the valid constitutional claim caused by the use of an extreme mental restraint on Jeff Weinhaus during trial. The ruling argued that this restraint was hidden and therefore could not have biased the jury. However, biasing the jury was not the pleading in the case. This mental restraint, capable of delivering severe and potentially fatal electronic shock, is designed not to physically restrain the defendant from harming someone, nor to bias a jury by maligning the defendant, but rather it's designed to impede defendant's constitutional right to testify in his own defense. Petitioner's constitutional right to defend himself was unlawfully restricted by the presence of this device on his body and the implied threat to his open verbal testimony that it represented. So that's what happened with the federal court habeas ruling, and why we believe that it was flawed. And then there's been a lot of really significant stuff happened since then. After this happened, a ruling was issued in another case, which I wasn't even aware of. But Folsom had filed a suit against the state of Missouri, or the Missouri Highway Patrol, for firing him. And they fired him. Everything in the case is about the Jeff Weinhaus case. And the case of Folsom versus Missouri State Highway Patrol was released, and the judgment was released in the last few weeks. And the judgment contains a lot of stuff. There's a lot of stuff still hidden in that case because it was under a protective order. But there's a lot of stuff that, Jeff's lawyers should have known way back at the trial, and they didn't. And I just like to read some of it. This is coming from the conclusion in the appeal that Folsom was denied relief from the Missouri State Highway Patrol, and from Dr. Lutz that examined Folsom and said that he could not work in law enforcement because he had post-traumatic stress syndrome. His post-traumatic stress syndrome had been diagnosed in 2000, and he had been medicated. And it says, because of his post-traumatic stress syndrome gives him false signals of being under threat, he is fearful of pulling a gun and shooting somebody when they are merely reaching into their back pocket for a wallet. So it appears that Sergeant Folsom was relieved of his duties on the day that he shot Jeff. And he was never allowed to work again. And I'll get into that a little bit more here. So when this case that Folsom lodged against the Missouri Highway Patrol was operating simultaneously with Jeff's habeas case that I just read about earlier. And the respondent in both Jeff's habeas case and Folsom's case against Missouri was the state of Missouri, and under the Attorney General at that time, Josh Hawley, who is now a U.S. Senator. So Josh Hawley was in possession of all this information, which would have led to, he was in possession that there was a Brady violation at the initial trial that should have led to Jeff's acquittal. And he also, in my opinion, committed a Brady violation because he didn't reveal the information from the Folsom case in the habeas case. He argued strongly to deny Jeff habeas corpus, and was successful in his arguments because he withheld all this evidence. And in the Folsom case against the Missouri Highway Patrol, just about all of the depositions are covered under a protective order. Indeed, in any of the documentation of the case, even that stuff about Jeff, about Folsom might shoot somebody if they were reaching into their wallet. The only place I can see that is in the conclusion in the appeal when it was finally released, because all the information was under a joint stipulated protective order. So both parties agreed to this protective order to keep everything confidential, including officers involved in the original case and informants. There's that dreaded word again. And so all this was privy to Josh Hawley, but we can't even see it to this day. And, it seems very likely that within that protected information, there's a lot of information that would have helped Jeff get a fair hearing at his trial or in the habeas corpus petition since then. And so since all this occurred, Jeff Weinhaus was contacted by the Missouri State Public Defender's Office, and they're considering helping him try to get justice in the state courts and get this thing overturned in the state habeas case. I'd just like to talk a little bit about the time frame of what happened. I'm gonna read some stuff here from Folsom's petition against the state of Missouri. So it says, plaintiff, that's talking about Folsom, was employed by the Missouri State Highway Patrol, Troop I, from 1997 until his employment was terminated in December of 2014. Folsom has post-traumatic stress disorder arising out of an on-the-job shooting and injury that occurred in October of the year 2000. Folsom takes prescription medication for his post-traumatic stress syndrome. On or about September 11, 2012, defendant Eberhardt, that was Folsom's boss apparently, ordered Folsom to go to St. Clair, Missouri, and to arrest Jeff Weinhaus, an individual who had made public death threats against plaintiff and other state officials. That's really not the facts, but that's what's in the case. And then it talks about, going to the area where Jeff was shot. It says, following this confrontation, Folsom was ordered to submit to a drug test. Said drug test revealed that Folsom was taking medication for his post-traumatic stress syndrome. On or about that time, Folsom informed defendant Eberhardt of his post-traumatic stress syndrome. Missouri State Highway Patrol, acting through Captain Eberhart then relieved plaintiff of his duties. So on that day, basically, or the next day, he had failed this drug test, and it doesn't say exactly what the medication was, but all those treatments for post-traumatic stress are psychotropic drugs, and whether it was one of the ones that's labeled for it, whether it was off-label or illegal, we're left to wonder. Yeah, and then so from December of 2012 to the end of plaintiff's employment, plaintiff was required to submit fitness for duty evaluations. So he was relieved of his duties, but he was kept on the payroll. For 2 years, they paid him to do nothing. And it looks to me like they wanted to control him until Jeff's trials were all over and his appeals were over. And Jeff was convicted in 2013. He appealed, and when that process was finally over in 2014, they immediately dismissed Folsom. So it looks to me like, Senator Josh Hawley committed a Brady violation because he was aware. I should have mentioned, in the original case, when Jeff was shot, he, it's a miracle that he survived. He had wounds in his head and his chest, and I don't know how he survived. But he was in the hospital for a month, and he accrued large medical bills at the hospital. And, authorities never came to the hospital. Miraculously, they saved Jeff. He left the hospital and was out for 3 weeks before they arrested him. So obviously, they didn't consider him dangerous, but they didn't want to pay for his hospital bill, even though they shot him, tried to kill him. So that's where we're at. It looks to me like there's an obvious cover-up in the case by the Missouri Highway Patrol. The prosecutor and or the Missouri State Highway Patrol committed a Brady violation in the original trial because they withheld evidence that would have likely led to Jeff's acquittal. It appears to me, from what I can see, that the current U.S. Senator from Missouri, Josh Hawley, committed a Brady violation in his response to the habeas corpus case because he was sitting on a bunch of information from another case, and he knew that this information would have likely led to Jeff being granted a habeas corpus relief, but he didn't reveal it, and successfully got Jeff's habeas petition denied. So I think, there needs to be a real investigation into all this activity, everything, all that protected information. I think the current Attorney General, needs to look through there and be honest. I believe he is an honest man. I don't know, but he needs to look at this, and he needs to do it right now, and I hope we can get Jeff out of jail soon. Thank you guys very much, and I hope this helps clarify what's all going on, and message me if you need more information. Oh, I forgot to mention, some of you know that I was arrested in February going to see Jeff and trying to get answers why he was being held in solitary without being allowed to contact the outside world. The next day, he was allowed to contact the outside world and has been ever since. He's now back in the honor side of the prison, which is very good. He's been treated well since this occurred. About 4 months later, they have pursued charges against me for trespassing at the public lobby, even though I left. That's going to be heard on the initial hearing on that is the 12th. But, I've lost job opportunities and various things because, like Emmett Bundy has been talking about the last week, they put you on these lists, even though you've never been convicted of anything. And that's where I'm at. But I can't say any more about the case, but that's what's going on. I think September the 12th is the first hearing on that. So God bless you guys. Thank you, and hope we can keep shining the light and help get Jeff out of jail. Thank you.